Sometimes it takes a lot of legal skill for a trademark owner to win a domain name dispute. But when the facts are just not on your side, no amount of skill will make a difference, which is exactly what happened in a decision involving the domain name, wait for it, skill.com. In this dispute, under the UDRP, the Uniform Domain Name Dispute Resolution Policy, the trademark owner apparently did not obtain a trademark registration for the word skill until 2021, and the domain name was originally registered in 1995, 26 years earlier. In most cases, that fact alone would make it impossible for a trademark owner to establish the bad faith element of the UDRP, but this dispute was a bit more complicated. The UDRP complaint was filed at WIPO by a company called Skillful Communications against another company known as Aquint. The decision was just issued in May 2022 in favor of Aquint, denying the complaint and refusing to transfer the domain name to Skillful. It's an interesting case because Skillful uses the domain name skill.net, which it uses in connection with a website that says the company helps organizations conduct more effective interviews by using artificial intelligence-based interviewing and training solutions. And Aquint, the registrant of the disputed domain name, skill.com, uses the domain name in connection with a website that says it offers access to job recruiters and candidates. So identical second-level domains and similar, although not identical services. Those facts often make for strong UDRP cases. But as in every UDRP case, the similarity of the domain names and the associated websites are not the only issues to consider. This case, like many under the UDRP turned on the third element of the three-part test, which I discuss in detail in episode 8 of my masterclass on domain name disputes, What is Bad Faith under the UDRP? As I explained in that video, and as I discuss with my clients all the time, the UDRP requires a trademark owner to prove that a disputed domain name has been registered and is being used in bad faith. And as the panel in the skill.com case noted, this is a conjunctive requirement, meaning that a complainant must establish both that the domain name has been registered in bad faith and also that it is being used in bad faith. As I often tell my clients, it's usually not possible to establish that a domain name was registered in bad faith if the complainant's trademark rights did not exist as of the date of registration. Indeed, I often quote from the WIPO overview, which says that subject to certain exceptions, where a respondent registers a domain name before the complainant's trademark rights accrue, panels will not normally find bad faith on the part of the respondent. So if 26 years passed between creation of the skill.com domain name and Skillful's trademark registration, why was this case even filed in the first place? And the answer is because of an exception that I referred to just a moment ago, and a little bit of ambiguity about what the word registered actually means under the UDRP. So here's a timeline of what happened in the skill.com case, according to the facts in the decision. The domain name was created on May 1st, 1995, under the name of Mac Temps Incorporated. In 1999, Mac Temps changed its name to Aquint Incorporated, and the registrant of the domain name was updated accordingly. At some time in late 2007 or early 2008, the domain name was transferred from Aquint Incorporated to Aquint LLC. And in 2021, it started resolving to a website for a network of recruiters. Meanwhile, Skillful Communications, the complainant in the UDRP case, obtained a trademark registration for the word skillful in 2016 with a claimed first use date of 2010, and a trademark registration for skill in 2021 with a claimed first use date of 2020. So if the only relevant comparison to be made was whether Skillful's trademark rights existed when the domain name was registered in 1995, the answer would be easy and the complaint would be denied. But the case was complicated by the issue that the registrant of the domain name changed through the years. And as the WIPO overview says, if a respondent acquires a domain name after the complainant's trademark rights accrue, then it may be possible to find bad faith registration. But Ultimately, the panel said the facts did not qualify for the exception. Specifically, here's what the decision says. When a domain name is transferred from one entity to an unrelated entity, the change in registrant is considered a new registration. However, while a transfer could result in a new registrant being listed, panels have recognized that where a respondent can provide satisfactory evidence of an unbroken chain of possession of the disputed domain name, such formal changes or updates to registrant contact information will not be treated as a new registration. This is often the case when a transfer is between entities within the same corporate control group and has been done for a legitimate business reason and not simply for purposes of evading a procedure. And applying this analysis, here's what the panel ultimately concluded. Respondent has established an unbroken chain of possession in the disputed domain name since 1995. The late 2007 or early 2008 transfer of the disputed domain name was to a controlled subsidiary of Aquint Incorporated, and there is no evidence that such was done to take advantage of any trademark rights complainant might claim in its newly adopted skillful mark. The transfer appears to simply be a change of which company within the corporate family would hold the disputed domain name, much in the same way that companies often move the ownership of their trademarks between holding companies and operating companies within the same corporate control group. Now, there were some other interesting issues in the decision in this case, including whether the trademark skillful is identical or confusingly similar to the skill domain name, and whether Aquint had rights or legitimate interests in the domain name given the descriptive nature of the word, but the panel did not address either of those issues because the bad faith finding alone was sufficient for it to deny a transfer. Also of interest is that the panel did not address the issue of reverse domain name hijacking, or RDNH, which a panel can find when a trademark owner attempts to use the UDRP itself in bad faith to deprive a registrant of its domain name. In any event, the panel did write that any dispute between Skillful and Aquint over the skill.com domain name was really not even appropriate for the UDRP, concluding that the matter was simply not a case of cyber squatting. So, this was ultimately a good reminder that dates are important in the UDRP's bad faith analysis, whether it's the date on which a domain name was registered or the date on which the current registrant acquired it, and also whether any changes represent something deceptive or nothing more than what's called an unbroken chain of possession. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.